Good morning to all the members of this court. This is Attorney Jose Enrico Valenzuela-Alvarado representing UIA. Good morning. May I proceed? Well, basically, I only have 4 minutes, so I will be very brief. I would like to point out first that this case has turned moot not because of the deposit necessarily by the Union, but because of the decision rendered by the United States Supreme Court in Llanos, specifically in June 2018. While this case was pending, this decision was issued by the U.S. Supreme Court, and precisely what we did.
But why wouldn't they, I mean, once Janus was issued, I mean, you essentially confessed to judgment, although there was disagreement as to who was to pay, but why wouldn't he be considered the prevailing party, just based upon the law of the case?
That's precisely the main issue here, because we thought that since the beginning where we were going to argue this case was going to be as to the prevailing party's situation and to the attorney fees. But despite of that, appellant opted to argue that he cannot withdraw the money that was deposited pursuant to the decision of Janus,
so
which...
Are you willing to concede that he is legally the prevailing party?
Not, Your Honor, because that's not the correct process that he argued before the district court. He, instead of arguing that, opted to file a situation stating that he cannot withdraw the money pursuant to Rule 67 and 68, arguing specifically that the case of Campbell provides that situation, but in those cases that he quotes during all the entire brief, and also after my research, I cannot even find one single case that has to do with this situation with only one plaintiff. The Rule 67 situation that he argues very extensively has to do with class actions.
So you're saying that he proceeded on the wrong theory?
Wrong theory, wrong process, and wrong arguments. Since also, right after the Janus decision was rendered, the Secretary of Justice issued a memorandum that applies also to the Department of Labor, directing specifically to these agencies and to all the government to apply Janus as it was decided by the United States Supreme Court.
But in fact, there is an attorney's fees question, right?
No.
Whether he'll get them or not. Are you saying he's waived the right to attorney's fees?
Yes, Your Honor. We extensively argue that in our briefs, specifically throughout the end of the brief. There was no one single quote or specific case law cited during the briefings in the district court, neither in this case before us. Also, the attorney fees has a term to be filed within the district court. So in the event that this honorable court decides that he's a prevailing party, how can that be returned to the district court if it was never interrupted the term to doing so? So if the plaintiff waived his argument since the beginning, it's going to be too very long shot to understand if he can do that right after now.
You're thinking the only way he can get attorney's fees at this point is if we say that the district court erred and should have granted his motion for summary judgment based upon Janus. Then he would clearly be the prevailing party.
I cannot predict that because I cannot get into the mind of the judge, but Janus is the one that decided, not the summary judgment.
But are you saying that even in that event, the request for attorney's fees would be waived?
Yes, Your Honor, because...
Yeah, that's what I think you do sound like you're saying. You're saying just the way this case came to us,
yes,
and the way they've argued it, they've just lost their chance to get attorney's fees.
That's precisely the main bad decision that was taken by plaintiff's attorney, even in the district court or also in the briefs before this first circuit. Because basically, we are not arguing if he was a prevailing party either, because summary judgment from both parties on the cross motions, they never underline the decision because Janus went into...
Just ask you one last question.
Yes.
Is your mootness argument, you're arguing it's moot?
It's moot because of Janus.
And is your mootness argument dependent or takes as a premise that they've waived the request for attorney's fees?
Both, yes.
Okay.
Anything further, Your Honor? Any other questions?
Just one thing. Janus made them correct on the law.
Janus provides a decision that the executive branch is the one to execute laws within our constitutional system. So if one decision from the judicial power, in this case the U.S. Supreme Court, said that this is going to be applied, the executive branch has the obligation to apply and to execute that order from that judicial forum. So that's what happened here. That's why the Secretary of Justice issued an order.
But in a pending suit, Janus made their case on the merits correct.
Yes, but they waived the argument to be a prevailing party. So we cannot disagree or agree with Janus.
Unless we say that the court should have granted their summary judgment motion.
Because of Janus?
Yes.
That was not what the court order said from the U.S. District Judge. The court says that it was decided upon the decision of Janus. And then the case turns moot because that's why we are here now, because of the decision that we thought that that the plaintiff it was going to be asking for attorney fees, but he also waived that argument. Any other questions, Your Honors? Thank you.
Thank you, Counsel. Attorney for Appellees, Puerto Rico Aqueduct and Sewer Authority. You have a 3-minute argument.
May it please the court, Attorney Alberto Tavales Maldonado for the Puerto Rico Aqueduct and Sewer Authority. I think here the issue in regards to the contested funds and the prevailing party issue and everything misses the point. Here, I don't think it was specifically briefed and argued. I do agree with the court's opinion on that, or at least the line of questioning that was provided during Brother Counsel's argument. But interestingly is the fact that here the case, contrary to what plaintiff's appellant's argument was that it was the Rule 67 that became the case moot, we do echo the fact that the decision of the district court was very clear that it was firstly because of Janus, and that resolved the declaratory judgment. And the injunctive relief was technically waived because of the actions of the union and the authority as to the opinion issued by the DOJ and the Puerto Rico Department of Labor, so we stopped withholding union dues. And as to that point, we agree with the fact that here the entire appeal is based on an incorrect premise that that was the sole reason, that the Rule 67 deposit was the sole reason for the mootness of the claim, when it really wasn't. But aside from that point, as is.
As to the back payments, though?
No, not as to the back payment.
Right, so, I mean, Janice, once you stop withholding, once the withholding stops, there's no need for any forward-going relief. They want the back payments, right?
That's what they requested, yes.
Yeah, and Janice doesn't answer just the determination by the Supreme Court in Janus doesn't itself moot anything. They still have to get a judgment that will enable them to get access to the funds they want. As I understood it, what the district court said is, I don't have to rule ultimately on the merits of that question because the money's been deposited, because after Janus, you chose to deposit the money. And then they said, but you can't do it that way. That's not a right place to put it, and that doesn't do anything. And then unlike in Bias Yaakov and these other cases, rather than it just sitting there, the district court ultimately said, and you can have it.
Yeah. And we agree with that. We believe that the fact of the case is that everything that happened led to the mootness of the case, and the money is, in fact, there for his asking. There has been anything that has been is the inaction of the plaintiff, and that's where we're here. We agree that he could have requested it, but he didn't.
And with respect to attorney's fees, do you think that was waived, or is that just not your interest?
Yeah, I believe the fact that it is our position that that was not argued before this case, and specifically to that point on the brief merits is that has been resolved by the Supreme Court that an interest in attorney fees is insufficient to create a case in controversy under Article 3, given the fact that the underlying claims have already been resolved. Thank you.
Thank you, Counsel. Attorney for Gonzalez Colon. You have a 3-minute argument.
May it please the court, Attorney Francisco González Magás, representing the Governor of Puerto Rico. To be honest, I don't think there's very little to add from my point of view. The government has always stated that we have no objection to the plaintiff having access to the money that's being deposited. As to the mootness, which we believe is the cause of the appeal, we stand with fellow Appellees in the point that we believe the mootness is based on the Janus finding and not necessarily on the filing of the Rule 67 funds. When the Janus finding came down, the government of Puerto Rico issued its interpretations, and
That only speaks to the going forward. When you stop withholding
sure.
in response to Janus, that moots the going forward relief.
Well, we believe it moots the entire case because it settles the controversy in the case, and there's no longer a case or
How do
controversy.
they get the money that they think that was improperly withheld? How do they get that money? Don't they need a judgment?
I believe that, the district court has already stated that the money is there for their taking. They can request it.
That's because of the Rule 67. That's not because of Janus.
But the Rule 67 would never have happened if Janus hadn't come down. And I think it's a bit of an issue of the chicken and the egg here.
Without the Rule 67 thing happening, in the absence of a judgment by the district court that you owe the money based on Janus, that you're owed the money based on Janus, then they wouldn't have gotten the judgment that they would need. The thing that's mooting it now, as far as I can tell, the only thing, is the district court's ultimate determination that the money is yours for the taking.
And that determination wouldn't have happened without the Rule 67 filing.
Whatever it wouldn't have, that's the thing that's
But
mooting it.
But I don't think you can just divide the issues here.
Don't you
Your
need
Honor.
like a judgment just to close a case? Because this is a case that there's no judgment.
There is a judgment in this case, and the judgment in the case found the case to be moot. The basis for finding the case moot was the Supreme Court's decision in Janus and the interpretations of it.
That's not what it said. He said the reason it's moot is because the money is there for your taking in the Rule 67.
Well, Your Honor, if I may, if you look at the opinion and order in page 36, it states, in all the case is moot, and then goes on to cite different cases where different circuits have already found the cases to be moot based on the government's or the defendant's reaction to Janus, that which may include.
Reaction to Janus on the going forward basis.
Yes.
Right? Yes.
But those.
What about the past payments? What is mooting that?
The past payment, meaning what is already the Rule 67 filing here,
Things that were deducted.
the refunds.
Shouldn't there be an amended judgment saying the case has become moot, but as to the amount that is owed, the court hereby orders that it's been deposited, the court hereby orders that it be paid or something like that?
Our position, in our brief, we state that we have no objection to a determination by this court saying that, they have access to the money and they just, correct whatever mechanical process was not
But
achieved.
you have no objection that we simply order a one-liner, correct the judgment to say, judgment also includes entitlement to that amount as conceded by the government, and that's part of the judgment. You have no problem with that.
I have no problem with that, Your Honor, but that is not to say that I'm not entering into the issues of attorney's fees or prevailing
No,
party.
that would leave it, that would be a.
Limiting my
another day.
position to whether they would have claim to the money. We have no objection to this court granting them access to the money right now.
Am I misunderstanding something?
Excuse me?
I thought the Rule 59E ruling says that already.
I believe so too.
Okay.
And that's one of the things I've never
So if we
been very clear as to
consider
why he
that-
hasn't gotten the money yet, Your Honor.
Okay, thank you.
But should we also construe it to say that they have a judgment for that amount?
Well, there we would have a problem, Your Honor, because I don't believe that just having access to that money means that they are prevailing party under the applicable definitions of prevailing party.
But at least they should have a judgment saying they're entitled to the money which has been deposited in the court, and that's a judgment. And they would then have to raise the issue of attorney's fees.
Up until that point, we have no objection, Your Honor.
Can I just understand, is the Rule 59E ruling, was that not reduced to a judgment?
It may have, Your Honor, but the thing is, it doesn't necessarily give the plaintiffs prevailing party
I'm not asking about
status.
prevailing party, I'm asking.
I believe it could have
I
been.
thought it was reduced to a judgment.
I mean, I believe so too, and again,
So then the
it's
judge-
never been very clear to me why the plaintiffs have not asked for the money at the district
Because they have a
level.
judgment saying they can get it, which is that judgment based on the Rule 59. They just think it was illegal to have issued it, which is puzzling since it was in their favor.
In my mind, as a litigator, I request something and I argue it, and if I'm denied, then I come up to the First Circuit. So I've never been very clear as to why that hasn't happened in this case, and we will have no objection to the plaintiff having access to the refunds that have already been deposited before the court, but more than that, I don't have a...
Okay, thank you.
Thank you, counsel. Attorney Gilliam, please reintroduce yourself on the record. You have a 3-minute rebuttal.
Matthew Gilliam for Plaintiff Appellant Reynaldo Cruz. This court in Alstom Caribe explained why this exercise of correcting the district court's Rule 67 errors and shortcuts is not just a practice in quote-unquote mindless formalism, and it vacated a wrongful deposit in that case.
Okay, so if, what I ask opposing counsel just right now, if we were to issue a one-liner to the district court, amend the judgment so that include that the amounts deposited will be paid to the plaintiff, you would be happy with that?
Yes, if judgment was entered for the plaintiff for those amounts, then yes, that's what we're seeking. That's what we're saying would resolve the Rule 67 issue, but
What does it mean when we say judgment was entered for the plaintiff? Right now, is there a judgment following the Rule 59E ruling?
yes, there's a judgment that, well, it's not a separate judgment, but they dismiss.
Incorporates all the, and it
Just
dismissed the
basically-
case. And then all of the reasoning is part of that judgment. And if we construed that judgment to say the money was in that judgment determined to be yours for the taking, would you have a problem with us saying that?
If judgment is entered for Reynaldo.
No, I'm just telling you what the judgment that was entered, if we issued a ruling saying, the judgment that was entered said the money was yours whenever you asked for it, and that is what the district court ruled, and that was the basis for mootness ruling, and in consequence, it's moot. What would be wrong with us saying that?
I don't know that that's really a judgment in plaintiff's favor.
Okay, so now you're saying it, but that's not, that goes only to the prevailing party point, correct?
Yes, and to the ability of the court to disperse the money.
No, because we would say that the order has said that you can get the money. And that just under that order, the district court would give you the money. You might think, gee, I'm shocked he's doing that, but that's what the order and the judgment said. There's nothing wrong with that.
Yeah, I understand, Your Honor, and I
So I think what it really comes down to why you don't like that is because it bears on the prevailing party point.
yes, and I think that it's inconsistent with this court's precedent and the federal rules.
Well, great, but the thing that hurts you, as opposed to an abstract interest in the law, is the prevailing party point, correct?
Yes.
Okay, and so what do you have to say about why that's not waived?
It's not waived because there was no judgment that entitled Mr. Cruz to even seek attorney's fees at that point. If this court takes that action.
Make that specific argument below.
Well, we did make our argument in reply to the union raising that the attorney's fees issue is moot, that no, we can't have waived that issue because it was never,
But you could have filed a motion for attorney's fees. The judge could have denied it and saying there's no judgment for, which would allow you to, but that never happened before.
No, but we had no entitlement at all.
Would you have a
to
problem
attorney's
if we remanded it for the district court to consider the mootness issue in light of whatever arguments parties may wish to make about attorney's fees and how they may bear on mootness?
Well, I think that.
Yes or no? Would you have a problem with us doing that?
No, Your Honor, I don't think so. It may depend on the specific.
And we can retain
contents.
jurisdiction.
Right.
Or what if the remand order would be, again, one-liner, as conceded by the plaintiffs, by the defendants, plaintiffs are entitled to the amounts deposited, judgment entered accordingly. You're okay with that also?
Yes, if judgment is entered for Mr. Cruz, we are okay with that. That's what you're
That's
saying.
different than saying judgment is entered to dismiss the case as moot. That's the key.
I agree, and that's what.
That's
we're
why
doing.
when you answer Judge Helpe, you're really saying no.
Yeah,
Yeah, okay,
yeah.
thank you.
But the issue of prevailing parties and attorney's fees is really for the district court to resolve in the first instance if judgment is entered for Mr. Cruz.
Thank you.
Thank you, counsel. That concludes arguments in this case.